Hello, I'm Philip Sales. In this video, I'll be interviewing Murray Hunt, who's the legal advisor to Parliament's Joint Committee on Human Rights. We'll be talking about the role of the Joint Committee on Human Rights in the legislative process. Murray, what is scrutiny of a bill by a parliamentary committee?
Scrutiny of a bill by a parliamentary committee is an opportunity for parliamentarians to give detailed attention, line by line, to the detail of a bill. And to hear evidence about the controversial aspects of that bill, give civil society organisations an opportunity to make representations to parliamentarians about the bill, and generally to test the government's strength of the government's case in putting such a bill before Parliament.
And what is the purpose of scrutiny of bills by the Joint Committee on Human Rights?
Scrutiny by the Joint Committee on Human Rights has a more specific purpose. Its purpose is scrutiny for compatibility with human rights specifically. So it will look at a bill and measure it against various legal standards rooted in international human rights sources. And it will test the government's reasons for, if it's a bill which interferes with human rights, why that's a justified interference, and so on.
Now, the courts also scrutinise acts of Parliament for compatibility with human rights under the Human Rights Act. How does scrutiny by the Joint Committee on Human Rights differ from that?
Yes, scrutiny by the Human Rights Committee is a little more freewheeling than courts can be when they're scrutinising legislation's compatibility for human rights. It's less constrained by concerns about justiciability of the issue before the court. And much more concerned with the general question of whether the bill itself is justified and whether the particular interference is justified. And it doesn't operate under the same constraints in terms of the evidence that it may hear when it's trying to reach its own view about whether the bill is compatible with human rights. So it's generally speaking a much more unconstrained exercise in scrutiny.
What resources does the Joint Committee have?
It has myself as the legal advisor, two other lawyers as well, so 3 lawyers in total advising the committee. It also has, because it's a joint committee, it has a Lord's clerk and a Commons clerk, and it has some secretarial staff and some administrative staff to assist it. So it's not an enormously resourced committee, certainly compared to some North American committees.
And what does it mean to describe it as a joint committee of Parliament?
A joint committee is a committee which is comprised of members from both the House of Commons and from the House of Lords. So we have 6 members who are MPs and we have 6 members who are members of the House of Lords.
How do committee members work together when they come from different parties?
Interestingly, they work extremely well together. There's something about the language of human rights which I think helps them to overcome what might otherwise be sort of partisan differences. Quite often on the Joint Committee we find the members are discussing issues which are very contentious along party political lines, but because they're discussing whether the measure is consistent with human rights, they often are able to set aside any partisan differences on that issue and actually work within a framework which seems to be more conducive to agreement between them. So they manage generally to work by consensus.
You're an independent lawyer advising the committee. How does your relationship with committee members work?
Well, I advise the committee strictly on the legality or the legal implications of a bill that's brought forward by the government. And that will take the form of a written advice normally to the committee, which is circulated to all members. And then that advice might be tested, sometimes quite rigorously tested by some members in discussion in the committee. And sometimes members, if they are involved then subsequently in amending a bill or trying to amend a bill during its passage through Parliament, will then come back to the lawyers again later to discuss the implications of earlier advice which has been given.
When does the committee first become involved with a legislative proposal?
Usually it's not until the bill is actually published. So when the bill is first introduced into either house, it will land on the desk of myself or one of the other lawyers advising the committee. And that will usually be the first involvement that we've had with the bill. Occasionally, of course, there are draft bills published, and where those draft bills are being scrutinised by other committees, we will then sometimes get involved in advising those other committees on the human rights implications specifically of those draft bills. But normally it's when the bill is published.
And are you or the committee ever involved before a bill or a draft bill is published, at the stage when the government is still thinking about the proposals that it wants to bring forward?
Yes, we are occasionally involved, and increasingly we try to be involved at that stage. Since 2007, the last couple of years, the government's published its draft legislative programme, indicating the bills it intends to introduce in that session. And we found that's been an extremely helpful exercise because it's enabled the staff of the Joint Committee to meet with the departmental officials who are responsible for bringing those bills forward to try and identify at an early stage the sorts of human rights issues those bills might raise and to try and flag up the sorts of issues the committee are likely to be interested in.
Once a bill is published or a draft bill is published, what happens then, so far as the committee is concerned?
Once it's published, we try to react quite swiftly. So my task, or one of the other lawyers' task, is to advise the committee within 2 weeks of the human rights issues which the bill raises. And within 2 weeks of its publication, the committee will meet to consider that advice and to decide whether there are any questions that it wishes to write to the government to ask, which might be, for example, to ask for more evidence about why a particular measure is necessary, a particular interference with privacy, for example, is necessary. And then that that letter that the committee may send to the government is responded to within 2 weeks. And within the target is, I think, 10 weeks, the committee will try to report before report stage of the bill in the first house.
Whom do you deal with within the government department which is putting forward the bill?
Yes, the committee itself will deal directly with the minister responsible, so the minister who signs the Section 19 Human Rights Act Statement of Compatibility. So the correspondence, which all then subsequently gets published, is between the chair of the committee and the relevant minister. At staff level, there are often meetings and communication between officials, so the bill team and the leader of the bill team in particular, and the lawyers advising the bill team in the department will often correspond with the staff at the Joint Committee in order to try and work out if there are issues which can be dealt with before having to be dealt with in formal correspondence between the chair and the minister.
And how do you, as a legal advisor, provide advice to the committee about a bill?
Usually it's in written form and in the form of an advice note, often supplemented at a meeting of the committee as the committee discusses the bill and considers the advice, and questions arise in its own consideration of the written advice that it's been given.
How does the committee raise human rights concerns with the government department? Is it always done formally?
It's usually done formally in the form of a letter which can then be published. The committee has always set great store by transparency of its communication with government departments. So formality is usually the order of the day. So it will normally be in the form of correspondence between the chair and the minister, which then subsequently becomes published.
And is the government department obliged to respond to a report or a query by the committee?
I think, strictly speaking, as a matter of parliamentary procedure, it probably isn't obliged as such to reply. I think there's probably a pretty strong convention that such letters from committee chairs are responded to. There isn't either a strict requirement that the government respond as such to legislative scrutiny reports by the committee on bills, but in practice, increasingly, the government, I think, finds it useful to put out a formal response, a formal response to the committee's report.
And will the committee have every bill referred to it?
Yes, the committee looks at every single government bill which is published. So in this coming session there should be about 23 government bills, and each of those will be considered by the committee's staff. And the committee apply criteria that the committee itself has decided, the staff apply criteria that the committee have decided are the criteria to apply to decide what is a significant human rights issue. And it will then decide, the committee will decide in the light of the staff's advice which issues on which bills it wishes to scrutinise. So it will end up scrutinising perhaps a third to a half of the bills, and of those bills it will scrutinise specific issues within them.
What sort of things will the committee say in a report on a bill?
In a report, the committee may say that an interference with freedom of expression, for example, is in the committee's view disproportionate, or it might have reached the view that it lacks a sufficiently precise legal basis for the interference. It may also congratulate the government on having introduced a human rights enhancing measure. The committee's view has always been that credit should be given where credit is due in terms of human rights enhancing measures. And the committee may also, in some reports, say that an opportunity hasn't been taken in the bill to implement a human rights obligation or to take a human rights enhancing step.
What happens when the government's legal advice says that a bill is compatible with human rights, but the committee takes a different view?
That does arise occasionally, and there's no opportunity really in Parliament for that to be resolved in any formal way. The purpose of the committee's reports is to inform parliamentary debate, and there will then be, when the committee has reported, debate in Parliament about the competing views on compatibility. And some bills do raise issues on which there is sometimes disagreement between perfectly competent and reasonable lawyers, as we all know, as these issues end up being litigated to the highest courts. But often that disagreement will simply be the subject of the parliamentary debate, and then it may subsequently then be something to which courts refer in later litigation about the compatibility of the bill.
At what stage in the parliamentary process will the committee produce its report?
The committee tries to report before the report stage of the bill in the first House. And the reason it tries to do that is because that gives members of the committee an opportunity to put amendments to the bill to give effect to any recommendations the committee may make about the bill. So sometimes the committee will propose amendments to try and solve a human rights compatibility problem that it's identified, and it will suggest a specific amendment to the bill to render it compatible. And if it reports before report stage in the first House, then there's an opportunity for members to put those amendments and for there to be a debate before the bill leaves the first House.
And what is the purpose of a report from the committee? What is it trying to achieve within the parliamentary process?
First and foremost, within the parliamentary process, it is to try and inform parliamentarians about the human rights issues that a bill raises. So it's mainly to inform and to educate to some extent, to make available the evidence which is relevant to the issues which parliamentarians should be debating, and to provide some guidance and advice about the relevant legal standards, relevant human rights legal standards, which are in play in relation to a particular measure.
Does the committee take a legalistic approach? Does it give a sort of ruling on the bill, or is it trying to do something wider than that?
No, it's trying to do something much more reflecting its place in the political process. It is always guided by legal advice, which is my job primarily. But the committee has made clear that it takes its own view about compatibility, informed by legal advice. So it will seek to reach an independent view of its own, with the benefit of legal advice, on the compatibility question. And it seeks, and I think has had some degree of success in this, to try to make human rights less of a legalistic concept, so that parliamentarians don't get put off by debating the compatibility of a particular bill, and thinking it's just a preserve of the lawyers rather than the politicians.
So does it try to frame the debate rather than dictate the answer to a particular question?
Yes, it will. Sometimes it may be necessary for the committee to give quite a definitive view on something which is, in the committee's view, very clearly incompatible. But broadly speaking, it's more often the case that a bill will raise a question about balancing one right against another, freedom of expression against the right to privacy, for example. And there the committee will reach a view about where the balance between those ought to be struck. And then its report will try to, as you say, frame the questions which the parliamentarians should debate when they're debating that on the floor of the House.